I know somebody else who gets a little agita when it comes to this, and that's Mark Geragos. And the reason I know Mark Geragos gets agita with it is because he has a lot of high-profile cases in his past. He's here to help me break this all down. Of course, you know him. He's a criminal defense attorney. He's the co-host of the podcast Reasonable Doubt with Adam Carolla. So Geragos, I said there were two issues that I found in this whole conflict when it came to Ann Taylor and the three parents. Number one was that they have to be okay with it, and clearly Kara Kernodle is not. But then number two, they have to be notified. And that didn't happen either, at least in Kara Kernodle's case. So I want to get you to weigh in on this news, Mark, that they've had this meeting. They've gone through this review process and no conflict, the judges determined. What are your thoughts?
Well, I sent you the other day, Ashleigh, a op-ed piece that somebody had done in which they had basically analyzed the ethical rule here without giving you any credit whatsoever, by the way, and had said that there really was no ethical conflict. And I couldn't actually disagree more with the analysis. Number one, I think you've pointed out one key thing, which is you can't do this absent a knowing waiver by the clients. And why do I say clients? Both the current client, who is the young man who was accused of these horrific crimes, and the parents of the victims of these crimes. Now, the one part I will take issue with, and you know that I agree with you on gag orders. I always think gag orders have been inverted. We talked about this the other night. Originally, gag orders were instituted in Shepard v. Maxwell, which was F. Bailey's case back in the 50s, which later became the model for the fugitive. But they were originally to protect the defense. It's been perverted. It now is something that harms the defense, in my opinion. But when the lawyer, Ann Taylor, goes into chambers in camera, meaning she and the judge talk privately, I understand that. I've done that many a times. I will tell you when I've done it in many murder cases, when a client wants to get on the stand and it may be against my advice. Hypothetically, I might go into chambers with just the client and tell the judge this is against my advice, but it's their choice. So I can understand that. You don't want to violate the attorney-client privilege, or at least let the prosecutor hear it. In this case, I understand that. What I don't understand is how there can be a knowing waiver by the victim's parents, because I just don't think that there is any way possible that there isn't going to be a discussion of that house, the use of drugs, and people going in and out. I just find that entirely too hard to believe. I don't know if the judge said, okay, if we get to that point, then we're going to do further hearings on this and we'll table it. And as of now, you don't plan on doing it. But to my mind, that is in play. And to your point, that is potentially, God forbid, from the young man's standpoint, he gets convicted and later says, I've got a 2255 writ of habeas corpus, and my lawyer was ineffective because she didn't want to go there, meaning the house,
sure,
and drug use and things of that nature.
AKA ineffective assistance of counsel. We hear it all the time. It's like, I don't know if it's the number one appellate issue, but yeah, if I had a dime, I'd be on a yacht in Majorca. Yeah, it's the number one. I knew you'd say that. Okay, here's the other thing, another piece of breaking news. Yeah, okay, wait one sec, because I'm going to get you to talk about this one. So the sources that we have close to the prosecution have also told us that the prosecutors in this case are actually in favor of having her conflicted out. And I suppose I get that, because who wants to try a case twice? Who wants to do all that work and all those billable hours to the taxpayers of Idaho, and then, you know, a couple of years down the pike, after they might get a conviction, have it tossed out only to start all over again and put those families all through that again?
Well, look, the cynic in me would say, of course they want her out. She's one of the only qualified defenders in Idaho. So I can see that. But at the same time, the prosecutors have a very, I would say, easy way to raise this issue, which is to file the motion to say that they want the waivers by the respective clients. There's a U.S. Supreme Court case I believe it's Wood, that specifically talks about what you have to do in a situation where there is a conflict. It has to be on the record. I don't know if that, and we don't know if that was done already in camera or ex parte. Remember, there's two different ways this could be done. It could be done in camera, which means the public doesn't listen to it, and it can be done ex parte, which means the prosecutor doesn't get to get in on this. Or it could be a hybrid of the two. But I would be shocked if the prosecutor hasn't at least filed the motion, maybe redacting what they think or what they think they know. But I'm surprised that so far, and I haven't checked the docket, maybe it's been done, that they haven't filed for this, because the U.S. Supreme Court generally counsels that you do this.
Thank you for watching. Go to newsnationnow.com to find NewsNation on your television provider. And don't forget to click the red subscribe button below to get more of NewsNation's fact-driven, unbiased coverage.